The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good morning. Next case is in re Eldridge. We'll hear from the appellant.
May it please the court, Chief Justice and Justices, my name is Zealand McKinney. I'm a practicing attorney in Murphy, North Carolina, and I represent the defendant appellant, Davin Eldridge, in this case. Mr. Eldridge was found by the Honorable William Coward, Superior Court Judge, to be in contempt of his standing order prohibiting recording devices in the Superior Court of Macon County, North Carolina, in the courtroom. The conviction for contempt was upheld by the Court of Appeals, and the defendant appeals from the sentence given to him by the Honorable William Coward, requiring him as a special condition of probation to compose, and I quote this, quote, compose a typewritten essay on the subject of respect for the court system is essential to a fair administration of justice, unquote. The essay was to consist of between 2,000 and 3,000 words, and it was to be mailed to Judge Coward on a date certain for approval by Judge Coward after any modifications he would require. The defendant was required by the special condition of probation to post the essay on all of his social media and internet accounts, not only the ones that he owned at that time, but any that he would acquire during the period of his probation. In addition, the essay was to remain posted and attributed to the defendant without negative comment or other negative criticism by Eldridge or others during the entire period of probation. Under the authority of State versus Allen, we contend that the court should review this matter de novo since it relates to a statutory sentencing error. In North Carolina, by statute, a sentencing judge can impose conditions of probation that are reasonably necessary to ensure that the defendant will lead a law-abiding life or assist him in doing so. In addition, by statute, a sentencing judge in North Carolina can require a defendant to satisfy certain special conditions of probation devised by the court that are reasonably related to his rehabilitation. There's several cases that we've cited in our brief for that authority. In State versus Harrington, a case which is illustrative of exactly what reasonably related to rehabilitation means, our appeals court interpreted this same language and held that a special condition of probation requiring a DWI defendant to not go upon the premises of an establishment selling alcohol during certain hours of the day was reasonably related to the defendant's rehabilitation, and the court upheld that special condition of probation. Now, the court also said in Harrington that a sentencing judge has substantial discretion in devising special conditions of probation, but a judge's discretion in that regard is not without bounds. In State versus Everett, the court said that a judgment that suspended sentence upon conditions should be exercised with due regard to the defendant's other rights, and that such special conditions cannot be oppressive or unduly burdensome upon the defendant. Now, the plain wording of Judge Coward's special condition of probation requirement that there be no negative comments by Eldridge or anyone else to the essay during the period of probation really leads to one of two different results. In the first instance, when a negative comment is posted, Judge Coward could just find Mr. Eldridge has violated the terms and conditions of his probation and revoke him, and he would be going to jail for 30 days.
Mr.
In
McKinney,
the
I'm sorry to interrupt you, but I don't want to forget to ask you this. Can I back up for just a minute and ask you about the standard of review? You
Yes, sure.
referred to the Harrington case, which the state cites in its brief for the proposition that the review of the probationary condition is for abuse of discretion. And I think you asserted that it was a de novo review.
Well,
It looks as if that case was looking at abuse of discretion for a condition of probation. Why does that not apply here?
I think both those review standards of review apply here. You're reviewing it de novo, but I think that there's a limitation on the trial judge's discretion. His discretion is not boundless.
So then do we review this condition, the special condition of probation, to see if he abused his discretion in setting that condition?
Yes, Your Honor, I think you do.
Okay, thank you. Sorry for the interruption. Go ahead.
That's quite all right. And in the second instance, if Judge Coward chooses not to revoke the probation, then Judge Coward would be instructing the defendant to take down his post, or more importantly, the post of third parties. Now, the defendant, Mr. Eldridge, is engaged in a business. He has an online blog, and that's the way he makes his living, through advertisements on that website. If Mr. Eldridge is placed in a position where the free exercise of ideas and opinions on his website is restricted, that affects his livelihood. The whole purpose of the blog is so that there is an exchange, a free exercise of ideas and opinions. And that's paramount. And if
Mr. McKinney, are you then suggesting that a trial court abuses its discretion if a condition of probation somehow adversely affects the person in question's ability to operate his or her business?
I think there's some authority for that, Your Honor, in the case law.
Well, what would that authority be?
We have cited State versus Everett, and we've also cited State versus Harrington. In the court, in those cases, I believe mentions the idea that the court, the restriction placed by the court should be reasonably calculated to achieve real rehabilitation, but should not be exercised to damage the defendant's livelihood.
Well, if I understand the record in this case, and please correct me if I'm misunderstanding it, that's helpful by itself if you do that. If I understand what happened in this case, your client went into a courtroom for the purpose of recognizing that he was running a risk of having problems if he videoed proceedings in the courtroom. He knew that he was not supposed to, but his purpose in doing so was to put the material that he was, and I know this is an old-fashioned word, but I'm not technologically sophisticated enough to use the correct one, filming. He put that up on the website that presumably is the one that he operates in connection with his business, so that it seems to me there's a basis in the record for finding that the very conduct that resulted in the finding of contempt involved the operation of his business. Under that set of circumstances, why is it an abuse of discretion for a trial court to adopt a condition of probation or suspension of the sentence adversely affects his complete freedom to operate his business as he chooses?
Well, Justice Irvin, the prohibition was to not record in the courtroom. The prohibition was not to control the content of speech or the content of what someone was going to be able to share online. The prohibition had to do with not recording in the courtroom.
But at least as I understand it, he recorded the information for the purpose of providing it to the public on this, and I'll mispronounce it, Trap Appalachia website. Is that an incorrect understanding of the record, or was that in fact the reason that he recorded?
No, I think that is in the record, Your Honor. But what I'm saying to the court is that the restriction by Judge Coward was not to record in the courtroom. Judge Coward, in his standing order, did not try to control elements of speech. What this special condition of probation does, it tries to control speech on the internet, and I just can't see how that's rationally or reasonably related to Mr. Eldridge's rehabilitation.
Well, your colleague, and I was going to ask this anyway, so I'll ask it now. Your colleague in her brief suggests that the reason that there's a rational relation between the condition and the rehabilitation of your client is, in essence, and these are my words and not hers, she can correct me if I misstate them, but it seems to me that her argument is, in effect, the conduct of your client that led to the contempt citation was essentially failing to show proper respect for duly entered trial court orders controlling what happens in the courtroom. In other words, showing disrespect for the trial court's authority. In the event that he is allowed, in the event that he allows, either by his own writing or by somebody else's writing, to make comments that further adversely reflect upon the integrity of the trial court's proceedings in the comment section relating to the posting of this essay, that then that not only doesn't further his rehabilitation, but in fact shows that he is not rehabilitated. That's a poorly stated version of her order, but I mean, her argument, but I think that's what she said. Why is that argument not valid?
I don't think the argument's valid for this simple reason. If you read the text of Judge Coward's order, my client's probation can be revoked if a third party makes a negative post on the internet, on his website, because that's a requirement of the order, that there be no negative post. Now, if the order had read, there can be no negative, that if the order read that my client had to take the negative post down within a certain period of time, you know, I guess we'd be in a different, I'd be making a different argument, or we'd be in a different situation. But if you look at Judge Coward's order, my client's probation can be revoked if a third party makes a negative post.
Well, as I recall, it's been a while since I've handled a probation violation matter, but as I recall, in order for a probation violation to result in sanctions, there has to be a willful violation of the term and condition of probation by the person that's on probation. Assuming that's correct, are you really contending that there's a risk that your client's probation will be revoked if somebody made a comment in response to the posting of this essay that your client never had an adequate opportunity to take down?
I think there's certainly the possibility of that, and that leaves complete discretion with Judge Coward. How long is too long? Is 24 hours too long? Is 48 hours too long? Is a week too long? What if my client takes a 2-week vacation to the Caribbean and is unable to remove the negative post? I mean, it's just a sentencing provision, Justice Irvin, that should not have been placed in an order in this state.
All right. Thank you, sir.
Let me follow up on your concern about the impact upon your client's business. How would you reconcile that position with the common practice of trial courts to allow defendants to, as a term of special probation, to serve jail time on weekends, even when an individual might have work time on weekends. By your position, is that something that would be inappropriate for a trial court to do because it impacts one's business?
No, I don't think so.
What would be the difference?
Are you saying in a situation where the court offered a defendant weekend jail time or forced the defendant to take the jail time?
Well, as a requirement, just to keep things equal, as a requirement of special probation, that the individual serve the time on jail weekends because perhaps there's a consideration concerning the impact upon the jail population for whatever reason, overcrowding or what have you. So as a result, the jail time is mandatory on the weekends, even though that impacts the work opportunity for the criminal defendant.
Justice Morgan, I think that's comparing apples to oranges because you're with the sentence on the weekends, we're talking about an active sentence of incarceration, and I think that's within the court's sentencing prerogative under the statute. And Judge Coward, he didn't have to give my client a suspended sentence. I realize that, but according to our case law, if he gave him a suspended sentence, it could not be an oppressive or burdensome sentence. And
do I hear you conceding that the trial court in this case could have in fact given your client an active term of 30 days?
Yes, Your Honor.
Did your client also have the wherewithal under the case law and even the statutory law to reject probation and actively serve the 30 days?
He did not reject the suspended sentence.
Under the statutory law, did your client have the wherewithal, should he have chosen to do so, to actively serve 30 days?
Justice Morgan, he could have done that.
And in that situation, then he would not had to have had the burden, I take it then, of worrying about the impact on his business if he'd elected to do the 30 days and get it out the way.
That's correct. He chose not to do that.
So in terms of probation, then, in terms of your concern, or as you express it for him, his concern about the impact on his business, he did have an alternative to the probationary term, which at least that day he elected to take.
That's correct.
Thank you.
I'd like to ask a clarifying question. It sounds from your argument that what you're contending exceeds the judge's authority under the statute is the restriction that there be no negative comment or other negative criticism, similar to the dissent, which said requiring him to compose the essay and post it was related to his rehabilitation, but that the monitoring of comments was not. Is that what your argument is to us?
Yes, Your Honor. But in addition to that, when you talk about negative comment, what does negative comment mean? Right. Is negative comment what Judge Coward says it is, or is there some objective standard to measure what negative comment is?
Right. And a second question I have is, it's true, isn't it, that if your client wanted to avoid any consequences from negative comments, he could just disable comments on his blog for this posting? So there'd be no comments.
Well, and if he disabled all comments on his posting, what would his blog turn into? The purpose of his blog is to further discourse.
And I also just want to be clear, you're basing your argument entirely on the statutory grounds and have not argued the First Amendment constitutional grounds.
I have not, but I would say this about that. The case law that we've cited in our brief states that the court, in fashioning a suspended sentence, cannot ignore the defendant's other rights.
Thank you.
Let me ask you something about that. The state has contended in its brief that any constitutional argument was waived because it wasn't presented to the trial court. What do you have to say about that?
Your Honor, our focus in our brief and my focus in the argument today is that the judge abused his discretion in fashioning this special condition of probation.
Okay, thank you.
Counsel, do you desire to reserve your remaining time for rebuttal?
Yes, Your Honor.
Thank you, counsel. We'll hear from the appellate.
The Supreme Court. May it please the court, my name is Teresa Townsend, and I will be representing the state of North Carolina in this matter. The defendant's conviction for criminal contempt is rooted in his internet presence and his communications with his readers in cyberspace. The trial court's imposition of a special condition requiring defendant to post his essay on respect for the court system without negative comment or criticism goes directly to the heart of his rehabilitation and reformation. And we would request, and therefore the trial courts and the Court of Appeals majority decision should be affirmed. The dissent holding does narrow the issue to just one, and that is whether or not this special condition is reasonably related to defendant's rehabilitation, and whether or not it will lead him to a law-abiding life or assist him in doing so. There has been a three-pronged test established in the North Carolina Court of Appeals on determining whether a special condition of probation is indeed authorized by the statute. And that is, number one, whether it bears a relationship to the offense committed by a defendant, in this case, criminal contempt. Number two, whether it tends to reduce his exposure to crime. And three, whether the condition assists in defendant's rehabilitation. And as we discussed previously with Mr. McKinney, the standard here is abuse of discretion. And according to the case of State v. Good, in this particular type of situation, it is a gross abuse of discretion. And in this case, we contend that there has not been a gross abuse of discretion. It is noteworthy that the majority and the dissent all agree that the fact that defendant has to post the essay on his internet sites, just those that he owns or controls, without negative comment, is not a problem. The only problem, or negative comment of his, the only contention is whether or not other third parties may put on negative comments on his sites. As indicated by Justice Earls.
I'm sorry, Ms. Townsend, maybe I misunderstood what you said. Is it your view that the trial court's order does not prohibit the defendant himself from making negative posts?
No, it does indicate that he may not make any negative comments or criticism.
That's what I thought, and I thought I heard you say something different, and I wanted to make sure I wasn't missing something. Sorry.
I appreciate you letting me clarify. No, it's only if third parties, that's the issue in front of the case of this panel. As Justice Earls indicated, a Facebook account can be blocked. This particular essay can be blocked or disabled so that there can be no comments. It would not be a burden on a defendant to do so when he posts his essay, and therefore doesn't need to concern himself whether or not somebody puts a negative criticism and then might be in violation, which I agree with Justice Morgan and Berger, that obviously one violation or one criticism is not going to put a defendant back in jail. Another part of that is, and we've discussed the fact, could he be put in jail instead of worrying about the special condition? He flaunted on the internet that he knew he could not do any filming in court, was going to do it anyway, and that he might end up in jail. So he acknowledged the fact that he knew what he was doing was illegal. Criminal contempt is a crime. It is there to preserve the court's authority and to ensure that court's orders are obeyed. Looking at the three prongs of Allah, we believe that all three prongs would be considered in the affirmative. First of all, the reasonable relationship to the crime. This is criminal contempt. In this case, he acknowledged online that he was going to do this, as we discussed, and even was commented by a third party as to why are you going to be put in jail, and responded to that. Defendant used the internet to advise third parties of his contempt of a court by voicing this intent. His requirement to ensure that his essay be posted without negative goes directly to the form of online communication showing defendant's contempt of the court. The court had the opportunity to actually see the defendant, observe his demeanor, obviously knew the facts of this case backwards and forwards, and determined that this condition was one that he felt necessary in order to ensure defendant's rehabilitation and that defendant would not be exposed to more criminal behavior. He has there's a possibility that a third party might indicate, hey, you didn't go to jail. That's awesome. And that could give him the opportunity to feel that he could circumvent the criminal system again by committing this offense again. So it does reduce his exposure by not being given comments that might make him more susceptible to not doing what the court system requires. In fact, this court, in a case that it's not quite on point, but similar, is the Smith case way back in 1950, where the trial court required that the defendant not operate an automobile, even though the crime for which he was convicted was larceny. And although there did not seem to be a connection between the two, this court indicated that the trial court noted that he may have considered his primary need was to be kept off the roads due to a strong suggestion in the record that the defendant was somewhat addicted to alcohol. Well, in this case, we have a defendant who is susceptible to others, and who may also be somewhat addicted to boasting about his illegal activities on the internet, and needs to recognize when negative comments or criticism of the court system may provoke him yet again to commit the crime of criminal contempt. And does it assist in his rehabilitation? I think it definitely does. Yes, it may. It was his business, as indicated by, I believe, Justice Berger, that caused the situation in the first place. He decided to stream, even though he knew he was not supposed to. He did it on his Facebook, and therefore committed contempt of court. In doing so, the trial court, based on his past history and the facts of this case, determined that this probation was necessary. So we do feel that it's not a gross abuse of discretion, that in fact it was very narrowly tailored to the fact that it was to be his particular sites that he owned or controlled. had nothing to do with anyone else's sites. If somebody wants to express something negatively on another site, that is not covered under this particular provision. We would, if there's no questions at this point in time, we would ask that the trial court and the North Carolina Court of Appeals majority decision be affirmed. Thank you.
Thank you, counsel. Rebuttal.
Mr. McKinney, you're muted.
I'm sorry. With respect to counsel's argument, the one thing she doesn't explain to the court is how the court, who had complete control over this article and the content of the article, how does posting that essay that basically the court would compose and draft without negative comment by the defendant or third parties on the internet, how would that further the defendant's rehabilitation in this case? She never answers that question. And I'm lost as to how that could further the defendant's rehabilitation. If the court has complete control of all of that. And that would be my argument. Thank you.
Thank you, counsel. Madam Clerk.
Oh yes, oh yes, oh yes, the Supreme Court of North Carolina is now in recess. God save the state and this honorable court.